In this video, overview of an eviction case, we will go over the initial stages of an eviction lawsuit. We'll do this in some detail and we'll include the following: giving a proper notice, serving the tenant with a summons and complaint, giving required evidence to both the tenant and the court following Rule 26.3, and the immediate occupancy hearing. So let's get started. The eviction process starts when you give an eviction notice. As the owner, you must serve the tenant or other person staying in the rental without your permission a proper eviction notice. Sometimes this is called a notice to vacate. Anyone over the age of 16 can serve an eviction notice in Utah. And notices can be served in one of the following ways. First, you can deliver it to the tenant personally. Second, you can mail a copy by registered or certified mail to the tenant at the tenant's residence. 3, you can leave a copy with a person of suitable age and discretion. In Utah, usually this is around age 14. And then mail a second copy to the tenant at the tenant's residence. Or 4, if a person of suitable age or discretion is not available, you can post it to their door. The first and last methods are the ones most recommended and most used. When posting to the door, the proper way to do this is to place the notice face out with the text showing, and then tape all 4 corners to the door. You'll want to post, take a picture, and knock. That is, you'll post the notice on the door, take a picture of it, and then knock. If the tenant answers, then you delivered it in person. If not, you posted it to the door. Either way, you have proof of what you've done. You may also want to take a witness or digital photograph for proof of proper service. You can find more about this in the Utah Code. It's at section 78B-6-805. Now, it's important to select the right type of notice for your situation, and this can be somewhat confusing. This is also found in the Utah Code, and it's at 78B-6-802. You can also watch the video that we've prepared titled, "How do I know which type of eviction notice to use?" If you do this step correctly, then the tenant does not comply. The court will find they are in unlawful detainer for each day they stay in your rental after the deadline on the notice. If the tenant does not obey the eviction order that you legally served them, then you will need to take the next step and get a court order to force them to leave. You will do this by legally serving them with a summons and complaint and then filing this with the court. The summons tells someone they are being sued and gives the tenant 3 business days from the date of service to respond to the complaint. Now, it's important to note that the rules for serving the summons and complaint are stricter than the rules for serving the eviction notice. They are typically served in one of 3 ways. They can be served by a sheriff, by a process server, or by certified mail. You also need to know that you cannot serve the papers in your own case. They must be served by a sheriff, a constable, or any person 18 years or older who is not a party to the case or a lawyer for a party in the case. A convicted felony sex offender cannot serve these papers, nor can a respondent in a protective order action. You can hire someone to do this for you and then include the costs in your complaint. Once the summons and complaint have been served, you must file proof of service with the court. Now, if you cannot find the tenant or you do not know their identity, or if service on all of the tenants is not practical, you can file a motion with the court asking for service by alternative means. If this is something you need help with, you can come to our Pro Se community clinic and speak with a volunteer to learn more about how to do this. Along with the summons and complaint, you must provide evidence to demonstrate the basis for your request for the eviction and the facts supporting your case. These are called disclosures. You will need to give the following: any written rental agreement, unless you had a verbal agreement or there was never any rental terms discussed. You'll need to give the eviction notice or notices that have been served, an itemized calculation of past due rent, damages, and any costs that you're alleging, the factual basis for the eviction, and this is usually found on the eviction notice that you served, and a notice to the tenant about their obligation to give these types of disclosures back to you. At least 2 days before the hearing, you will need to serve all disclosures to the tenants that you intend to use by the method most likely to be promptly received. This includes any additional documents that you want to use. It could be the ledger, it could be emails or texts or video evidence, anything that you want to use at the hearing to support your case, and also the name, phone number, and mailing address of any witness that you intend to call at the hearing. If a tenant files an answer to your complaint, then you can request an immediate occupancy hearing. This is a hearing to decide who gets to possess the property. The answer is the tenant's response to your complaint. If they file one, the hearing will be held within 10 days. If the tenant does not file an answer, then you can request a default judgment. Either way, if the hearing is scheduled, you must attend. Now remember, whatever evidence you want to use at this hearing must be disclosed to the other side and to the court at least 2 days before the hearing. When the hearing starts, the judge will be collecting facts and information to decide who has the right to occupy the property while the case moves forward. The judge will listen to information from both sides about the eviction notice, the summons and complaint, and the specific facts of your case that each side has alleged in their disclosures. The judge will use this to determine whether the tenants can stay in the rental or if they must move. Now, as the plaintiff, you have the duty to prove your case. The tenant can ask for more time because of extenuating circumstances. These are just things that make it very difficult for them to move quickly. Maybe they don't own a vehicle, or it's a very large property. Anything like that that might require extra time. If they make this type of argument, you also have the right to explain why letting the tenant stay might be harmful for you. For example, you might not be able to afford the mortgage on the property if you're not receiving rental income, or you might be trying to sell the property. Things like that. If that's the case, be sure to tell the judge. Now, if at the time of the hearing you still have not come to an agreement with the other side, the judge will issue a decision. He will say one of 3 things. Either you get the property and all the tenants or occupants must move immediately. You get the property and all the tenants and occupants must move, but they have a specified time to get their things out, and the judge will state the exact date and time. Or the judge will say that the tenants or occupants get to stay in the property while the case moves forward. If the judge evicts the tenants or occupants, then you must file what's called an order of restitution and have it served on them. This is the eviction order, and it directs the sheriff or constable to evict the tenant and return possession to you at the date and time specified by the judge. You must serve the defendants with the order of restitution along with a request for hearing regarding enforcement of an order of restitution form. This form lets the tenant request a hearing if they disagree with how the order of restitution was enforced. Now, if you think you may have made a mistake in any part of this process, you can get help by attending the Pro Se Community Clinic and speaking with a volunteer. It's held on Thursdays from 11 a.m. to 1 p.m., and you must sign up at least 1 hour in advance. You can also reach out to Utah Legal Services to see if they can provide you with legal representation, or you can learn more about free or reduced cost legal services by watching the video, Where Can I Get Free or Reduced Rate Help? If after an eviction happens, you want to receive a money judgment because the tenant still owes you money, more steps are needed, and you can learn more about this by watching the video, How Can I Collect Money the Tenants Still Owe Me? Thank you so much for joining us today and watching this video.